Interested in what is it that you're looking for that makes the determination, yes, we go forward or not.
Okay. So, moving on to cases, questions about litigation, a little bit different than talking about what we'd advise a family to try to prevent it from happening, right? Okay. So, under the New York State Public Health Law, basically, the nursing home is required to provide all of the reasonable and necessary care that each resident needs for their particular medical conditions. It's not a one-size-fits-all type of situation. In New York, the regulations actually go a little bit further than they do under the federal statute. And in New York, the regulations require that a bedsore should not occur unless the facility can prove that the bedsore was what's deemed or known as unavoidable. And that has a legal definition in the law. Because of the nature of litigation and practice in New York State, which you've been involved in for many, many years, the process of bringing a case takes so long that stage 1 and stage 2 bedsores really are not actionable. The damages are not, unfortunately, significant enough to justify the long, parade through litigation. They really need to be a serious stage 3 or stage 4. And for the most part, stage 3 bedsores are not going to qualify. It's really the stage 4 bedsores where you have a photograph that show a significant skin breakdown. Certainly if you have complications like infection, osteomyelitis, sepsis, that's going to throw the situation into a case where we're going to litigate it.
So that sounds to me like it's only the most serious bedsores that actually get into litigation. Let's talk about litigation. Where do you bring a bedsore case?
So depending on a couple of different scenarios. So we like to bring the bedsore cases. If we can bring them in the first department, we do. You can't bring every case in the Bronx or in Manhattan. So certainly one of the venue questions is, where is the executor of the estate? Once there's an executor or an administrator appointed, wherever that person resides, you could bring it there. You could also bring it, obviously, in the county where the nursing home is located. There are some folks who have brought cases in federal court. I don't recommend bringing a bedsore case in federal court. That's a whole nother discussion. But the discovery rules in federal court, I don't think favor a litigant on the plaintiff's side. So we bring them in state court, and usually it's going to be venue where the fiduciary lives, the administrator or the executor, or where the nursing home is. And also, sometimes you'll have additional defendants, a physician, a nurse practitioner in some cases. And again, using the venue rules that we have, we'll venue the case where we think is the most advantageous to the plaintiff.
If someone mentions a borough, any one of the 5 we have, is there a pattern of nursing homes? Nursing home X, there are a lot of bedsore problems. Nursing home Y, not too many. So I'm just wondering, is there a coalescing of bedsore problems in some nursing homes and not others?
Most definitely. So if we take a look at, for example, if we look at Nassau County, I just did a video about Cold Spring Hills, which is a nursing home that's infamous for a myriad of reasons. The Attorney General brought a very serious lawsuit against them for misuse of funds, which has become a big issue in the nursing home world. So we do see clusters of nursing homes that tend to have the worst results. And again, that speaks about the ownership of those nursing homes and speaks about how the revenue that's coming in through Medicaid, through Medicare, and private insurance, how that's being used for staffing and for providing the care that the residents need. One of the big issues in nursing home litigation today is analyzing, through use of really what are public reports, how the money that the nursing home is taking in is being used. Is it being recycled back into the operating budget? Are they hiring enough staff? or is money going to places that is not benefiting the residents? And again, that's something we can certainly talk about because that's become more prevalent over the past 5 or 6 years, certainly since the last time you and I got together and discussed this.
When you talk about a stage 4, and there are 4 stages, you're talking about, as we said before, the most serious cases. Without getting specific into a particular case here and there, what on average would someone with a stage 4 bedsore be looking at in terms of litigation and value?
So again, a lot of it depends on the individual. In other words, the level of pain and suffering that you can prove. Just to go back to the public health law, again, these cases, if we're looking just at a bedsore case against a nursing home only, we are not really talking about a medical malpractice claim. We're talking about a claim under the statute, a statutory violation, which has defined damages in the statute. And in our statute in New York, we have a very unique set of circumstances because we can recover for a stage 4 bedsore where there's provable violations of a regulation that caused that injury. We can recover not only for the pain and suffering of that individual, we can also recover separately for the violation of the regulation as long as we can causally relate it to the bedsores. And that's 2 lines on the verdict sheet now. If you can link the person's death, if they're unfortunate enough to pass away close in time to this bedsore developing and being treated, and there's proof that their death was somehow linked to the bedsore, that's a third element of damages that you can recover for. And that's not a wrongful death claim. That is death as an injury under the New York State public health law. And the fourth element of damages, which is very difficult to recover for in New York and is the subject of a lot of motion practice, are punitive damages. Because the regulations, Public Health Law 2801D, allows for punitive damages, but the case law that's developed over the past several years has made it hard to prove that. But there are up to 4 separate elements of damages that you can recover.
Since we're talking about average clients, just use that word and give a little definition as to punitive.
So punitive damages in a bedsore case is defined statutorily. It's not common law punitive damages. And as you know, in New York, to obtain punitive damages in, for example, a medical malpractice case, you have to prove such a high level of intent, it's almost akin to criminal intent in New York, right? If we sort of take a look at the case law and how to summarize it. Under the New York State public health law, in a nursing home setting, if you can show that the failure to provide the care that was required was reckless or willful, you should be able to go to the jury on punitive damages. However, the one caveat to that is that as case law has developed mostly at the trial court level, where defendant nursing homes are making motions to dismiss the punitive damages claim, most of the trial courts are applying the common law punitive damage case law. So they kind of miss it. And I think that has to do with the fact that they feel that these claims really are medical malpractice claims when in fact they aren't. So it's hard to get. And really at the end of the day, you're looking at the violations of the public health law, you're looking at the pain and suffering and perhaps death if it's causally related.